Welcome, innovators. If you have a great product idea, but you're afraid someone's going to steal your idea, you may be wondering, what can you do to stop others from stealing your ideas and forcing you out of the marketplace? What you're thinking about is intellectual property. Hello, everybody. My name is Zook Pak. I'm a registered patent lawyer, and in this video, we're going to talk about a common misconception that people have about the different types of intellectual property, and that is patents, trademarks, and copyrights. Oftentimes, when I'm speaking with my clients, they will use the terms patents, trademarks, and copyrights interchangeably. And this is common even amongst our well-respected professionals. Check out this article about Michael Jackson's anti-gravity lean in his performance of Smooth Criminal. Here's how Katie Couric referred to this move. King of Pop's patented move. But what does Katie Couric mean by patented move? That Michael Jackson was the first to do it? That he's recognized for this move, or that he's the only one who can do it? Interestingly, later on in this same article, Katie Couric refers to the move as Michael Jackson's trademark move. So which is it? Is it a trademark move? Is it a patented move? Maybe it's a copyrighted move. Stick around to the end to find out, but for now, I'll discuss the differences between patents, trademarks, and copyrights. A patent is the intellectual property right you use to protect any useful process, machine, manufacture, or composition of matter. So what's a process, machine, manufacture, and composition? A process is basically a series of steps for making or doing something useful. Generally, it can be depicted using flow diagrams showing the steps involved in achieving an intended goal. Here is an example of a series of proprietary steps for maximizing the output of a windmill. A machine then is the actual device made up of various components working together to achieve an intended goal, such as the windmill itself from the previous example. A manufacture is basically something that is made for a useful purpose, like this golf putter. And finally, a composition would be chemicals, pharmaceuticals, drugs, and the like that has a useful effect. So as you can see, patents cover useful series of steps and useful products, as well as the machines that are used to carry out those steps or make those products, which includes almost anything. But what it doesn't cover are things that are aesthetic, artistic, literary, and the like. For these, you turn to copyrights. So what are copyrights? Copyrights are intellectual property rights that protect original works of authorship fixed in any tangible medium of expression. So what's a work of authorship? We're talking books, music, paintings and sculptures, choreographies, movies, architecture, and so on. And what's a tangible medium of expression? That would be the medium on which the work of art is stored. So we're talking things like paper, recordings, canvas, stone, drives and memory cards, and the like. So if patents cover useful products and processes, and copyrights cover the arts and entertainment, then what do trademarks cover? Well, a trademark is any word, name, symbol, or device, or any combination thereof that essentially identifies and distinguishes the source of one good or service from those provided by another. In other words, a trademark is the branding you use to distinguish your product or service from a competitor's product or service. For example, when you pick up a shoe, how do you recognize it to be manufactured by Nike? You look for the swoosh. When you pick up a purse, how do you recognize it to be a Louis Vuitton? You look for the LV. Those are trademarks because those marks allow you to identify who made the product. So, clarifying the first misconception in intellectual property law: patents are not copyrights, copyrights are not trademarks, and trademarks are not patents. Now, there can be some level of overlap, but we're not going to get into that here. The main point is that there are different options for protecting your ideas, and you should talk to a professional to flesh these options out. All right, now just for fun, having gone through the differences between patents, trademarks, and copyrights, let's go back to the article written by Katie Couric. Would Michael Jackson's forward lean qualify as a patented move, a trademarked move, or a copyrighted move? Well, there are levels of complexity here that we aren't going to get into, but from a simplistic standpoint, if you said copyright, I think that would be the closest answer, because Jackson's dance routine is a work of art covered under the category of choreographies, and the lean is part of the choreographed dance routine, which I'm sure has been captured on video, which would be a tangible medium of expression. Now, if you said a patented move, I'll give it to you. Michael Jackson actually does have a patent related to this move. But the patent is technically for the shoe that has a uniquely designed heel that allows for this lean. I think he could have gotten a patent on the move using the special shoe as well, but technically the patent only covers the shoe and not the lean. Well, that's it for this video. Hope you found it informative and entertaining because it's not legal advice. Nonetheless, I hope you liked it, and I hope you keep innovating in all areas of your life.